Disclaimer. No data subjects were harmed in the making of this podcast.
Welcome to the Privacy Bar and Bants podcast. We make privacy awareness simple. Sit back, relax, and grab your darkest privacy myths and misconceptions. Your mind-boggling experience begins in 5, 4, 3, 2, 1.
I love to drink water.
Anyway,
Right,
so
because
who am
you
I?
are.
I'm yet in the
Okay,
industry.
Next question. Next. Hello, people of the world. Hi, welcome to another episode of Privacy Bar and Bants.
So we have with us someone very interesting today. So we have with us Temitayo. Temitayo is a CIPM certified privacy practitioner who has earned the distinguished status of fellow in privacy. Not only is he a data protection specialist, he's also an InfoSec information security expert. He's a lead implementer and lead auditor for compliance with the ISO 27001 certification, which is one of the global standards for information security. He also has an LLM in European and international law, specializing in data law, and he has served as privacy counsel, privacy advisor, and information security advisor across several major organizations, including one of the big four.
Well, I'm not sure that's my. It feels like my boss's profile.
No, trust me, it's yours. It's not your boss. It's all you.
I'm just learning. Ours is a rapidly evolving space. You have to learn every day. If you don't, you'll be left behind. So
And learning is what we're on this podcast to do.
Yeah.
So, Temitayo, can I ask you something? So now that we have read all these fantastic things about you, can we just ask that? Could you kindly please just, just drop us some wisdom on this podcast? Can you just, as a favor to us and those listening to us, out of your sense of magnanimity, drop a little piece of your wisdom? By sharing with us like one privacy myth that you feel like urgently needs to be busted. Like they need to, I don't know, soak it in water, pour it down the drain, flush it in buckets and bowls of water, or like a constantly running tap. Like what is that one privacy myth that you want to be cancelled with like now? If you could cancel it yourself, that would be the first one you would go after.
Okay. Well, for me, my favorite would be the abuse of consent. So usually people say that consent is the most important legal basis, right? In fact, people associate data protection, people associate privacy with consent. That before any entity uses your data, you must consent. But that is not true. Well, at least in most cases. If you come to the European Union or even in Nigeria, there is no part of the law that says that consent is the most important legal basis, or consent is more important than any other legal basis, any of the other 6 provided in the GDPR, for example. There's nothing that implies that consent is the most important. But that notion is entirely contrived, I would say, by people because it's the easiest, really, to demonstrate. People think that it's the easiest, but from practice, they would even see that consent is not the most advisable legal basis for processing data.
I guess you can say it's one of the more difficult to manage.
It's one of the most difficult to prove, not manage per se, but prove.
Oh, okay, fair.
Yeah. As a practitioner, it's difficult to prove that you've actually obtained consent. But in a lot of cases, unless you're giving people documents to sign, or you're designing special tick boxes on the interface of the website that they can tick. But if you're not implementing technical measures per se, it's really difficult. And sometimes, in certain contexts, consent will be maybe inherently invalid. For example, in employment relationships,
Yes.
If you're my employee, and then I insert a clause in your employment contract that says you consent to me using your data, and then you sign it. That clause may be invalid ab initio because of the imbalance of power. There is no presumption of free will there. I don't have a choice. I have to sign it because I want a job.
Yeah.
So if you're using consent in the context of employment relationships, it would be difficult to prove that consent was freely given. The myth here is that there is this general belief that consent is the most important legal basis, and you need consent for everything. But that is not the case. Every legal basis has the same weight.
Yeah, so I find this very interesting because so recently I found myself doing a bit of work looking at data protection laws across Africa. And one thing I've noticed, not in Nigeria, but with a lot of other jurisdictions, is this sanctity of consent as a legal basis that they keep, I guess, pushing. So you'd see the term, you can only process data with the consent of the data subjects, and then the exceptions to that would then be the other legal basis. So it kind of, I guess,
Exactly.
gives consent this power that it doesn't
No,
have.
let me quickly speak to that. Let me clarify that. That's why I said in most cases there are exceptions. Now, if you look at jurisdictions in the MENA region, the Middle East and Northern Africa,
In Africa, yeah.
you look at their laws. Usually, consent is usually the most important. In fact, consent is usually the only legal basis.
Yes.
It's in the absence of consent that you don't that you if you cannot obtain consent, that's when you can have a recourse to other legal bases like contracts and legal obligation, public interest, blah blah blah.
Yeah.
But
Maybe
again, it's
legitimate
not best
interest.
practice. Really, it's
But
not best practice.
But then is that like a forward approach to this? Because if we actually look at it, consent is not easy. Because it's quite like when you think of all the things,
Exactly.
first
It's
of all,
why
it
I
has to
said
be free, it has to be freely given, it has to be obtained without the imbalance of power, there has to be all the right conditions, basically it has to be active. Where are we going? And then there's so many things that you can't do on the basis of consent, right? So what do we do with those things, and how do we navigate that issue?
it's why I said it's not best practice. It's in their national laws. If you go to the data protection of Algeria or maybe Somalia or many of the countries in the Middle East or in Northern Africa, you would see those provisions there. It's a constant thing. Yeah? And that was when there was a draft data protection law for Lagos states, that was the approach
Yeah.
as well until people screamed. Right? But
Yeah.
it's not best practice. If you go to the GDPR lists legal basis
Yeah.
in numerical form. But there is nothing that implies that one is more important than the other.
Than the other, yep. That's
They
a
all
very
carry the
important
same
one,
effect. They all carry
actually.
the same weight. You can choose whichever you like and rely on it. Whichever applies the most appropriate. But you don't have to go looking for consent every time.
This is a very, like, I feel like the topic of consent itself, I feel like it even needs like a whole episode to discuss, because I feel like the dynamics of consent, it's a lot more complicated than it might initially appear, and that in itself makes it worth like a bigger conversation, because really, I mean, like you said,
Yeah, yeah.
the impracticalities of consent, sort of, or the difficulties with dealing with consent, or obtaining consent, make we should look twice before making that kind of statement of saying you can only process data with consent, and when you don't get consent, because what do you then do with legitimate
Exactly.
interests, like when you have an interest, for example, CCTVs, or yeah, for, so how do you have to obtain consent every time you put up CCTV?
Exactly. So, I mean, again, like you noted, it's a separate conversation. You can spend days exploring all of the nuances on this particular subject. So, but yeah, I think that's one very predominant myth in the industry that has to be shattered down. It's a conversation that has long been settled. But in any case, I think that's one myth that we can probably have a separate conversation on in a different episode or something. But yeah,
Yeah, but can I ask you a
I
question, just
just
as a twist to this question
yeah.
now, this issue you've identified? So, which one would you say, like, for you personally, is the most like important in the sense of its utility? Um, um, and you can do it. Maybe you can give us two, maybe one from the business perspective, one from the data subject's perspective, or whichever way you want to do it. But which would you say is the most important
That
one?
that is it. That's one of the idea. That's the predominant idea of alternative legal basis is that there is no most important, right? It has to be treated on a case by case basis. Every scenario must be approached on a case by case basis, and
Yeah.
then you apply the most appropriate legal basis. There are some instances that some legal bases are specifically mandated. For example, for marketing communications in the EU, right? Explicit consent is required. You must consent, right? So you're not using consent because it's the best. You're using it because the law actually says that you must.
You must use it.
Do you get? So everything has to be approached on a case. So there is no best. It's all dependent on the scenario. Just look for the most appropriate for each scenario. So I said there's no one that is more important than the other. They all carry the same weight. It can be best all of them can be the best depending on each individual scenario.
So basically for you now, it's a situational thing. So something is best in some situations.
It's not for me. It's the best practices then. It's not for me. It's not just for me. That's the best practice. The best practice is that every case has to be approached on a case-by-case basis. Every scenario has to be approached on a case-by-case.
I mean, I feel like you've spoken like a true practitioner because, so for me, who's just like a sort of enthusiast, I look at legitimate interest very exciting me because I'm like, oh, this makes sense. It's nice. The approach that a lot of human rights centered issues normally go from is that of the data subjects. But I think this privacy is something that requires quite a healthy balance between business interests, individual interests. So I feel like legitimate interest for me just kind of balances really well. So I like it. I guess it's not so much as it's important.
But that's a big problem. That's a big problem. And if you like legitimate interest, there might be a problem, and I'll tell you why. Can you point me to what part of the Nigerian law
that gives us legitimate interest?
Can you point me to the part of the Nigerian law that states that legitimate interest is a
legal basis? No, and I think I find that ridiculous, if I'm honest.
Just saying, because let me see. It's extremely important that you understand what we're trying to achieve here and what the law says about legitimate interest itself. If anything, it should be your last recourse. If anything, because every time that you're relying on legitimate interest, there are 3 conditions that must be satisfied. Every time there are 3 cumulative conditions that you must look at. If one of them is missing, you cannot apply legitimate interest. You cannot base your processing on legitimate interest. The first one is the purpose of what you're doing. Are you really sure that you want to do this thing? What is the purpose? Is it that important? There is a necessity test as well, that the measure that you're adopting to implement that purpose, is this the only measure that you can? What are the alternatives? Is there any less privacy intrusive measure? Are there alternatives that don't really, that don't impact on privacy? That's the second point. The third factor is the balancing test, which is arguably the most difficult. And it is that whatever it is that you're doing, it must not override the rights and freedoms of the data subjects.
Yeah.
Those are 3 cumulative conditions that must be present. So every time that you're trying to rely on legitimate interest, you must document these 3 conditions. And that's where people fail. Right? When you're being audited and you rely on legitimate interest and you cannot prove those 3 factors, your processing is illegal. So it's even easier to go for less complex legal basis. So if I were you, it wouldn't be my favorite. It would be my last recourse.
Okay, Temitayo, it seems like we've gone really deep into that stuff. Maybe we should just dial it back a bit before we go on into that conversation and break down what these terms mean and give us a brief mind map to kind of understanding international data transfers so that people who aren't advanced in this space audiences can follow with the conversation.
I think that would be best, really. So let me even take it from the top. What do we mean by data flows, international data transfers, right? Data transfers, so there are different expressions. International data flows, data transfers, cross-border data flows, cross-border transfers. But they all mean the same, right? They basically mean the transfer of data from one jurisdiction, one country, to another. So there's a transfer from one entity in one country to another entity in a different country. That's what international data flows, international data transfers mean. So for the purpose of our conversation, I'll say it flows a lot. Now, that is a simple definition, but it gets a bit complex in the EU because of the political organization of the EU. Now, in the EU, there are 27 countries in the EU, right? Yeah. But each country is like a member state. So if you're transferring data from, let's say, Belgium to France, it's like you're transferring data from Lagos to Abuja. In that context, there is no international data transfer. It's a local transfer.
So like two cities in the same country.
Because they're in the same entity.
Yeah.
So the rules of international data transfers do not apply in that context. Similarly, if you're transferring data from between, Finland to Iceland, these countries are within the EU, there is no transfer. But in addition to countries in the EU, there are also some countries that are within the European Economic Area. Yeah. So the European Economic Area comprises all of the 27 countries in the EU and 3 other countries. The 3 other countries are Liechtenstein, Iceland, and Norway. So 30 countries altogether. So any data that goes through any of those countries, that is exchanged between any of those countries, is a local transfer. But if you transfer data from Finland to Ghana, or Finland to USA, or Finland to any other country outside of the 30 countries, the rules of international transfer would apply. Yeah. Now, what is the implication of the application of these rules? So, if you want to process data, you need a valid legal basis, right?
Yes.
Now, if you now want to transfer the data that you're processing, if you want to send the data that you're processing from the EU to another country, and this is how it works. Let's say my customers are, I'm based in, let's say, Belgium. I have a digital store in Belgium. My name is Nike. Customers are buying Nike shoes from me. Now, I want to maybe send their data to my branch in Ghana. Yeah. For some reason. Maybe my database here is not large enough and I need storage space in Ghana. If I send the names of my customer to my branch office in Ghana, there is an international transfer of data to Ghana, from Belgium to Ghana. Correct?
Yes, correct.
Exactly. Yeah. So, again, there are different mechanisms that have been established for this that are contained in the GDPR. Again, if you want to process data, you need a valid legal basis. Now, if you now want to transfer that data, as we've said, from, let's say, Belgium to Ghana, you need a second legal basis. You need an additional legal basis. Now, that additional legal basis is contained in Chapter 5 of the GDPR.
That's Chapter 5 we were talking about. Yeah.
Exactly. So, the law is saying that you cannot transfer data out of the EU. But if you want to transfer data out of the EU, you need to come to Chapter 5 and look for one of 3 clear mechanisms that are stated in this segment of the law. One of 3. If you cannot find an appropriate mechanism out of the 3, you cannot send your customer's data to Ghana or to US or to any other third country. Now, what are these mechanisms? The first one are adequacy decisions. Adequacy decisions are very simple. Again, the executive arm of the EU, which is the European Commission, would sit down. They would look at some countries based on their application, and then they would say, oh, this country has an essentially equivalent privacy framework. In other words, the privacy framework that they have in this country is the same as what we have in the EU. So we don't have any fear. We can freely transfer data to them. Now, it's a big privilege. It's a big privilege. If the EU can see that, oh, your country is strong, the framework that you have in your country is strong enough, you don't need anything. As long as the company is based in your country, you can freely transfer. You don't need any other measure. It's a privilege. Now, so far, only 14 countries have gotten that privilege.
Yeah, I was going to say, I think there are only 14.
Singapore, Israel, Jersey, Guernsey, and all of that. Just 14 of them.
Yeah, and most of them are actually like overseas territories that are either British overseas. Yeah, exactly. Or,
so,
yeah.
Or other fine countries with advanced economies.
Singapore, Japan,
even Switzerland.
Oh,
right?
yes.
So it's a beautiful thing. It's a really nice thing. Now, adequacy decisions too also, in some cases, they can be limited. They can be sectoral in the sense that they would only apply to companies that in the country that they've been given to. They won't apply broadly to the country. They will just apply to a sector in that country. For example, let's take Canada, for example. Canada enjoys an adequacy decision, but it's a limited adequacy decision. It's called, countries that have signed up to the PIPEDA.
Yeah.
PIPEDA is a sectoral Canadian law. It's for private companies that are that are bringing themselves that say, hey, we are committing ourselves to the principles of the better. Right? Those are the companies that you can only send data to. And that was the same situation with US.
Yeah, with the
in the
privacy
US, when they
shield.
used to have safe harbor prior to 2015, you could only send data to companies that have committed themselves to the principles of the safe harbor regulation. It was a document, it was a set of laws. So companies would take that document, they will read it, they will sign it and say, we want to bind ourselves to this. If they've done that, then you can send data to that company. But you couldn't send data to the whole of the US. So that's what a sectoral adequacy decision means. And that was what was given to the US through safe harbor. And the same thing was done through privacy shield, right?
Yeah.
Both of which are now invalidated. Safe harbor was invalidated in 2015. It was a set of regulation for transferring data between companies, safe harbor companies or privacy shield companies and the EU. Both laws are now invalidated by that very stubborn Austrian lawyer, whom I used to work with, by the way.
Oh, right? Oh, wow. So you're an ex-Trump.
So I used to work with his,
none of your business.
I used to work with his organization, yes.
None of your business. Wow.
Yeah. So that is the point. There are sectoral adequacy decisions, and then there are country-based adequacy decisions. Do you get? Yes. So that is level 1. Now, if you're sending data to a country that is not an adequate country, that is not one of those 14 countries, you need to apply appropriate safeguards. So appropriate safeguards are like risk-based measures that you need to implement to be able to send data. Yeah. Now, unlike adequacy decisions, appropriate safeguards are done on an entity-by-entity cases. It's not a country-by-country basis like you have adequacy decision, right? In fact, they are even done on a transfer-by-transfer basis. For every transfer that you do.
Do you have to do the... Yeah.
Right? Now, for appropriate safeguards, there are different types of appropriate safeguards. There are different types. There's the binding corporate rules. So how do binding corporate or BCRs, how do they apply? So let's say Nike in Belgium. There's a Nike in Belgium. There's another Nike in Ghana. There's another Nike in the Philippines. So what we can do is that all of the Nike entities, they can be 100 entities, they can be 100, as long as they are related, they can prepare one single document to regulate international transfers globally. And then they can bring it to the commission or a supervisory authority for approval. So usually what companies do is that when they do that document, they can call it whatever names that they like. They can call it an IGDTA, Intergroup Data Transfer Agreement, or they can call it an IGA, Intergroup Agreement. It means the same thing. It's a BCR. Now, the only advantage is that you can only share data between related entities. But the disadvantage is that you cannot send data to your cloud service provider, for example, the person that is storing your data for you in the cloud. Yeah. For example, as Nike now, you cannot send your data to AWS to help you save data, to help you store data.
Because they're not part of the group. Yeah.
Now, if you want to now send data to your cloud service provider, for example, you want to send it to another company that does something for you, right? A different entity, you can use a different type of appropriate safeguard, which is called the SCC, Standard Contractual Clauses. What are SCCs? SCCs are basically contracts. They're templates of agreements that the European Commission has prepared. There are 4 types, depending on the role that you play in relation to the data that's in your possession. So there are 4 modules. We call them modules. There's the controller processor, module 1, controller, processor, controller. So if you're a processor and then you're sending to another processor, you just take module 3. If you're a processor and you're sending data to a controller, you take module 4. So you just take the template that applies to you and just sign it. You cannot change anything in that template.
Standard. It's like a standard agreement.
It's a standard template.
Yeah, exactly.
You cannot change anything. You can only put your name. And then you can add, because the template has security requirements that you must meet. You can only add to the security requirements. Once you change a single thing out of that template, it becomes an ad hoc contractual clause, not a standard contractual clause. And what's the implication? It means that you have to take it back for signing. Because the standard clause is already pre-approved. Ordinarily, if you don't change it, you don't need to go and get it approved by a supervisory authority again. But once you change anything out of it, it becomes an ad hoc clause. You can still use it to transfer, but it has to be approved again by the supervisory authority of where you're at. That's so basically, that's the second tier of mechanisms. The third tier is derogations. Derogations they look simple on the surface, but they are not. Because derogations kind of look like original legal bits. Derogations, you need the explicit consent of the data subject. You can rely on vital interest. You can only use them in limited cases, on a case by case basis, and in emergencies, I would say. So in summary, there are 3 ways to send data out of the EU: through adequacy decisions, through standard contractual clauses, and through derogations.
Yeah.
Now, back to
the question.
UK. The UK has gotten an adequacy decision. So you can do free transfers of data between the UK and the EU, free exchange, because according to the EU, the UK has an essentially equivalent data protection framework, privacy framework. It's just like the EU, right? Now,
I mean, they were a part of the EU.
They were a part
before.
of the EU.
Exactly.
In fact, the domestic data protection laws that they have till today are still modeled on
GDPR.
the EU.
I think they even call them. They just say UK GDPR now, and
there's the UK GDPR and the Data Protection Act.
Yeah.
Right?
Oh yes.
But the fear with the UK now said, oh okay, because we want to start doing our own thing, we want to start sending data anywhere that we like, and that's the problem for the EU, because if you are collecting data from us, but you're not complying with our law, there is a problem. Because as soon as the data leaves the EU jurisdiction, it doesn't enjoy any protection anymore. It doesn't enjoy EU protection anymore.
It's basically relying on the recipients to protect it.
On the recipients, exactly.
Exactly.
So the EU would tell you that you can take, even for the adequate countries, that you can take data from us freely. But if you want to send that data to another country which is called a third party in this case, you will have to apply our rules. You still have to apply. Transfers like that are what we call onward transfers, right? So if you're doing an onward transfer, you need to apply EU data protection rules. Even if you are doing an onward transfer to 13 other entities, EU data protection rules have extraterritorial application, and you must continue to apply them. So the UK was saying, no, we don't want to apply. Once the data enters our territory, we do whatever we like, and then the EU have to call them to order. Now, what the UK did in March of this year, they released 2 different documents. The first one is called an IDTA, an International Data Transfer Agreement. The International Data Transfer Agreement is exactly like the EU SCC, Standard Contractual Clause. It's a template. So if you want to share data with an entity based in the UK, the entity will ask you to sign that document. So of course there are different modules to controller, processor, blah 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 blah.
Just like the SCC.
So you just take the applicable one and then you sign. So it covers that gap. So now it's no longer a concern, because there is a document that they use to protect data when it leaves the UK, just like the SCCs that you have in the European Union. So that's how that issue was sorted. It came out March 2000. I think March 2000, March this year, March last year. I can't remember, but I know it's something that is used in practice now to protect onward transfers from the EU.
Yeah. Okay. So that's what's currently in existence. I hope that answers your question. Yeah.
So, Temitayo, we have a podcast tradition that we would like to invite you to participate in. So this is the rapid fire segment. I don't know if you read our email, but basically we're going to be doing this rapid fire segment where we ask you as many questions as possible and see how many you can answer in under 1 minute. So basically you'll be timed this is exciting. Are you ready?
Do you feel like you're ready for what is to come?
Am I ready? Yeah.
Are you sure? You don't sound too sure. I'm not convinced.
Like I told you, like I said earlier, I will try my best and leave the rest to hobby.
Okay. Don't worry. We'll take it easy on you.
I hope so.
Don't worry. You don't have anything to be scared of. Okay. So, what does DPO mean?
Data Protection Officer.
Good. What does 2FA mean?
Two-factor authentication.
Great. What's your worst privacy nightmare?
Data breach.
What year did the GDPR come into force?
2018.
Give one example of a sensitive personal data.
Health information, biometric information.
What year was the safe harbor avoided?
Was it overruled 2015?
Close.
Safe harbor.
Yes.
2016, 2015,
Yeah, 2016, exactly. What year was the privacy shield voided?
2020, July 8, 2020.
Look at that. I think you got 7 questions. Literally, your time has just gone up, and I think you got 7 questions. We're gonna obviously recount this when we are like editing and all.
Hello there, listeners. Editing yesterday here. We did make a mistake on one of the rapid fire questions where we asked what year the safe harbor was voided, and the safe harbor was actually voided in 2015, 6th of October to be precise, and not 2016. So please let us all correct this. Thank you.
So that's the current relationship between the onward transfers issue as pertains the US and other jurisdictions, the EU UK framework. So what are we looking at in terms of the future of that relationship? So do you think it's going to blossom positively, or you think it's going to implode? Because I mean, it's really interesting to me. So one thing I find recurrent with the Brexit theme is that the UK was all very, very much we're not going to stand for this. We're leaving. We don't want anything that's we don't want this. We don't want that. And then you sort of see them sort of when they realize it's almost impossible because of the sort of, I guess, negotiating power that the EU has. You sort of see them retracting their steps. So things like even adopting sort of an SEC and renaming it something else, things like that. Like you sort of see them. But in the future of the relationship, do you think that they would eventually go with their position of we really don't care very much for the EU's data, we're going to do it on our own terms, you guys have to accept it? Or do you think that they would sort of just have to keep complying and just growing with the EU as is?
Yeah, so in this case, I think the latter would be the case. You can see that clearly from the IDTA idea.
Yeah.
Right? The UK does not. When it comes to size, the UK cannot exactly stand up to the EU. You can't stand up to 27 very powerful countries. When Germany's economy alone can rival the UK's. Do you get? Yeah. So you can't stand up to. At the end of the day, the UK would lose. Yeah, the UK would lose. So, and again, if you realize the objective is not a wicked thing. It's not the EU being petty. There is a genuine concern.
Yeah. But I think the issue is just because we've had this history of the UK and its surveillance history. I guess it's not really easy to deviate from your patterns. So I guess that's why the question is being raised.
Yeah. So a lot of compromises have been made before they got the adequacy decision. You should be aware that there were several considerations. In fact, when they left finally in 2020, the adequacy decision didn't come into place until 6 months after. There was like a 6-month transition window where they said, okay, you can keep pretending like we give you the permission to keep pretending like you're still in the union, but we want to take some time to deliberate on whether we'll give you an adequacy decision or not. And that took like 6 months, right? And in that period, they had to make a lot of compromises too. Maybe create better laws for surveillance, reduce government access to personal data, which is always a concern for the EU. So they had to make a lot of compromises, right? And again, remember that the objective is not a bad one. The objective is to ensure the security of data of EU citizens. So I don't see I want to believe that the UK is a forward-thinking government too. I don't see any reason why they would be resisting or fighting just to assert any kind of authority. So the idea is to always ensure that there's cooperation and to advance privacy protection as far as everyone can, right? The most vital data transfer corridor is the transatlantic corridor.
Yeah.
That's the corridor between the EU and the US.
And the US.
It currently is valued at about $7.1 trillion. That's a lot of money.
Yep.
Right? So if the US, you know what happened a few days ago?
Yeah.
You already mentioned the draft decision that came out for like a privacy shield plus or something. Yeah. If the US can comply with the grounds for invalidating the previous framework, privacy shield, there were a couple of concerns that were raised. So I don't imagine any form of serious resistance in the future. What I see actually is lots of cooperation in that regard.
That's very positive, and that's positive. I look forward to seeing the relationship, the relationship evolve and see where it goes. I mean, you mentioned the EU-US, the recent draft decision, which this episode is perfectly timed for. So I wanted to ask, how are we feeling about that? So I remember when I saw this, I said, I feel like the concept of reaching peace between the EU, US, and settling the transatlantic data transfer corridor would requires a whole institutional shift for the US. And I just don't quite believe that adequacy decisions or any other external factors putting pressure on them to ease that out will be sufficient. I think there's a lot that needs to change or be changed. So how are we feeling about that, first of all, and where do you see this going to? Do you think it's going to work? Do you think Max Schrems is going to be at the court ready to file another objection to this? How are we feeling about it?
My feeling, I feel I don't know. I feel maybe optimistic. I'm always optimistic about these things, and I'll explain why. So, what were the grounds for invalidating? What were the grounds for Schrems 1 and Schrems 2? Invalidating the safe harbor regulation and privacy shield. Three grounds, really. The first one was that the intelligence services of the US were having access to the personal data that were coming from the EU, right? So if Apple or some other service gets data from the EU, the FBI or the NSC can compel them to submit that data. That was one of the concerns. Yep. Another, which was really predominant, was that data subjects of the EU did not have legal remedies in the US. They could not enforce their data subject rights per se. If they request to enforce it and such requests were ignored, there was no real way to enforce those rights.
Which is a big problem.
Now, the third one was that the supervisory authorities of the EU did not really have any enforcement power in the US. So they could say that indeed we were fining you, but there was no real way to enforce it in the US. Those were the three. At least those were the three grounds for invalidating the first adequacy decision. That's safe harbor. Two grounds were cited for invalidating the second one, which was the first two that I mentioned. The fact access to intelligence, access to personal data for one, and lack of legal remedies. So there were correlations between these two. Now, in the agreement that were the agreement on the international transfer of data that was facilitated between Biden and what's her name, Ursula von der Leyen, the president of the commission and the US per se in March this year, some of these things were addressed, right? And very shortly afterward, well, not shortly per se, but in October, Biden signed an executive order to implement the commitments that the US, their commitments. Biden signed an agreement to actually implement them.
I remember that.
It was on the basis of those conversations that the draft decision came out. So I'm aware that some of these things have been addressed, right? In fact, like you said, an institutional shift, an institutional change is required. And if you read through some of the drafts of the adequacy decision, you would see that, or even the executive order, you would see that indeed there is an institutional shift. It might be minimal. For example, there is a body. Now, it's an entire office that data subjects from the EU can file formal reports at.
So I saw that in the executive order signed,
Exactly. So you can see that there have been deliberate attempts to fix some of the gaps that, were the grounds for invalidating the previous privacy frameworks. But again, ultimately, the decision lies with the Court of Justice of the European Union. But whether that new framework will stay or it will shatter again, it will collapse again, is something that we would have to leave to the courts to make a decision on. But I imagine that it would be around for a while, for a few years at least. But even if it weren't, I should say that currently there is an effective way to transfer data to the US, and it's SECs.
Yeah.
Adequacy
Can you
decisions
shed
are not
light on that actually? Because I feel like, so there's the gap that we're currently in, which is the gap between an adequacy decision and whatever is going to be signed soon. The gap between Privacy Shield and Privacy Shield Plus, or whatever we're going to have in the future. So what is currently filling that space? And as someone in the practice and in this space, what are the new challenges, new opportunities, the new angles and dimensions of this new era that we're operating in currently? Not new, but now currently operating in.
Yeah, so I already identified some of the changes in Privacy Plus, Privacy Shield and Privacy Shield Plus, right? The attempts to fix the gaps in Privacy Shield, that's to address intelligence access concerns. Again, the intelligence services of the US usually had access to personal data coming from the EU. So there have been attempts to, mitigate that in the new drafts. And also, there's a framework for giving legal remedies, for invoking and enforcing legal remedies for data subjects from the EU in the draft. I haven't comprehensively gone through the draft for the simple reason that it's still a draft. There will still be a lot of iteration till we have an eventual publication. But I know that there are attempts to fix what were problems in the past. Whether these attempts would be sufficient or not is something that I cannot speak to at this moment, because the only thing we have is a draft. But like I was saying, adequacy decision or not, there is still an alternative to transfer data to the US, and the standard contractual clauses. Now, as it stands, adequacy decision or not, 90% of data flows between the US and the EU are done with SECs anyway. You can see how
that was the case
important
preceding the
adequacy decision or not.
Yeah.
So you can see that it's even it's something that there is an alternative, but it might become increasingly difficult. Why? Because there are additional requirements for SECs now. Now they are saying that every time that you want to transfer, for every single transfer that you do, you need to do a TI, a transfer impact assessment, which is an incredibly difficult thing to do. And that will discourage a lot of entities.
Yeah.
Exactly, that would discourage a lot of entities. If you have to do that on a case-by-case basis, it will discourage a lot of entities. So as soon as the adequacy decisions come out, people will again swing back to adequacy decisions, which would be a good thing. But again, we don't know how long that will last before Max Schrems says, hey, I want to sue and invalidate this thing again.
I actually firmly believe that he's ready. As the draft decisions are coming out, he's looking through. And I don't mean this in an antagonistic way. I think I mean it in the sense of we're having positive privacy conversations because things are being questioned. And I think with privacy, as with most other human rights, the necessity of questioning rules and questioning regimes is important to advancing the space. So I actually when I say, when I make the Max Schrems jokes and I called you a shrimp earlier, I'm not actually saying that in like he's ridiculous. No, I think his efforts are necessary to have positive conversations about privacy and especially international transfers as we'll have it. Thank you so much so far. But I still have some questions for you. And I think for me, I want us to sort of bring the conversation back home to Africa to discuss what is the solution for us. Because I look at the EU and I appreciate the organization that has gone towards ensuring that the current system and framework that is in place, and I appreciate the sort of positivity and the positive influence that it has driven. And I now look at Africa and I look at how we're still currently even discussing privacy is sort of an afterthought in many regimes. In the few that do take an active decision to discuss it, it's still the conversation about international data transfer is still one that is lagging behind, but yet it's one we need if we want to really get to where we need to get to in terms of boosting the digital revolution in our continent. If you were to picture or paint the picture of an African privacy framework for cross-border transfer, what would you put in it? Would you say, okay, bye-bye to adequacy decisions, let's just focus solely on the risk-based approach, which is the use of SCCs, use of BCRs, like let's do it an SCC, but you need to do it here, it's transfer impact assessment. Like what would you, if you could write the template for an international data transfers regime in Africa, what would you put in it, is basically the question.
Well, the good thing is that I don't have to write a template for an Afrocentric data protection framework, because there is one already. Yeah. And it is the Malabo Convention.
Yeah.
It's something that is in place already. It's something that many countries are already signatories to. And a couple of countries have ratified as well, but we still don't have enough ratification as to bring it to life. But yeah, so one thing I would say is that we can completely forget the idea of having a GDPR. To be honest, I mean the Malabo Convention is like a GDPR, but on an African-wide level, I'm not so sure that we should be leaning towards something like a GDPR, and I explain why. The EU is a really cohesive system. Again, they don't function like one country. They don't function like
27
different countries.
Yeah.
They function like multiple states in one country, especially on subjects like data protection, right? But from my understanding, from my knowledge of the African landscape, it's almost impossible to accomplish. Because even in Nigeria, we can't even agree. We can't even function like a unified country. Talk less of attempting that on a continental level. That's one. Secondly is that we, to a very large extent, while global best practices are nice, it's important that we have domestic peculiarities as well. Our laws should be influenced by our domestic peculiarities. We can't be tailor-made. The truth is that. Yeah, the truth is that when it comes to fundamental rights, of course, the EU may claim to be a standard, but there are some things that may not be practical in our system.
Certainly.
There are some things that even if they would be, it would take a very long time. We're still developing, right? So if we're trying to copy or trying to imitate the EU word for word, we will run into problems. I'll give you very good examples. If you go to the implementation framework, I think page 17 of the
for the Nigerian Data Protection Regulation,
for the NDPR 2020, November 2020. If you go to that, you would see pages 17 and 18. I think you would see something that expounds on Article 2.1 of the NDPR, that's International Data Transfers, right? And there's a reference in the implementation framework. There's a reference to use of SCCs and BCR. And if you read that, you'll understand that the person that wrote this doesn't even know what they are really talking about. Right? Okay. And what you see is an attempt to really just copy what we have in the EU. It's an attempt to copy what we have in the EU, what we have in the EU. And it's not good enough. For us, we've started well. It may be slow, but we've started well. We are drawing a lot of inspiration from what exists in the EU, which is nice. But at some point, we have to look inwards too and see what applies to us and see how we can apply. We can start applying them to ourselves. Things that work for us, right?
Yeah.
Sorry, there is a role of education, enlightenment as well. Many people, that might be the bane of privacy practice, privacy framework of the African, the continental framework of privacy, enlightenment, education. People don't really
know
there's still
about
a gap.
it.
There's a knowledge gap. Yeah.
This is actually something I'm doing a bit of research on, actually. You can't have a system that relies on data subjects enforcing their rights and they not even being aware of the object of their rights in the first place. Like, there's no consciousness of how important your data is and how you should be sensitized towards, or, well, you should be aware of what you're giving up whenever you give out your data. And I definitely, that's a key area that I think even more scholarship should be written about, or should be available about. Thank you so much.
No worries.
So you were talking about domestic peculiarities. Are there any countries right now in Africa that has like there's a domestic peculiarity that you have seen them adopt or make allowance for that you think is worth like spotlighting. You could just briefly just give us an overview.
I would always refer to Northern Africa, like the constant thing that we talked about, right? Again, I still don't understand the rationale behind making consent the only valid legal basis and other legal bases as exceptions, but that's, I would say, would be a national thing. It's a national peculiarity. They have a reason for saying that. I don't know. Whether it works for them or not, I have no idea. I'm not Algerian. I've never been to Algeria. I don't plan to become Algerian. So I really wouldn't say. But the fact that they read the laws, they read global laws, and then they felt, oh, this is what we want to do, and they're doing it. And if it works for them, it works for them, right?
Yeah.
So yeah, that I would say is a national peculiarity. There's something that we do too, which may be a conversation for a different day, for another day, and it is a supervision of international transfers by the Office of the Attorney General. It's a weird inclusion. A lot of people still don't understand. A lot of people still don't understand the essence of that. But the fact that we're trying to link the, I would say, legal practice or, we're trying to link the law to privacy, to data protection. It could be a forward-thinking measure as well. The fact that the Attorney General would have some level of, influence on what countries should be on the whitelist or not, right? How that applies in practice, I don't know. But the idea could be nice. It is nice in theory, I would say. But how it would apply in practice, I have no idea. But that would be a domestic peculiarity.
Okay. Thank you so much, Temitayo. It's been fantastic having you on the podcast. We really, really appreciate you taking time. I know this podcast has been trying. So thank you so much for coming on the podcast. And we will certainly love to have you again sometime soon.
No worries. Okay. I had fun, and I hope that I've been able to contribute my limited knowledge on this.
Yeah. We had a good conversation though. It was nice. Thank you so much for coming.
Anyways, until next time.
Yeah, it remains our lovely DPO and I, Itunde. This episode was sponsored by Ikigai Innovation Initiative and was brought to you by Tech Hive Advisory.
And a big shout out to our executive producer, Ridwan Oluyede, associate producers, Dolapo and Yetunde.
This podcast was edited by Ayonfe Aino, shout out to her, and our podcast associate, Victoria Adaramola, and graphics by Okwe Abujade.